Welcome back to This Week in Immigration, our conversation on the stories that matter right now in immigration policy. I'm Jordan Lapierre. This week on the program, we'll find out what the words Queen of the Hill mean, why Attorney General Jeff Sessions will review some immigration court decisions, and the new rules on criminal prosecution and separation of children and families caught crossing the border illegally. But before we start, remember, you can subscribe to this podcast and all of BPC's podcasts on Apple Podcasts, Google Play, or wherever you get your podcasts. You can also stream on our website at bipartisanpolicy.org. And while you're there, you can find more information about all the topics we discuss on the podcast. Just go to bipartisanpolicy.org/immigration. Joining me today on the program are Theresa Cardinal-Brown, Director of Immigration and Cross-Border Policy. Hi, Theresa.
Hi, Jordan.
Chris Ramone, Policy Analyst.
How you doing?
And Laura Hall, Senior Manager at BPC Action.
Hi.
Let's start in the House of Representatives, where a rarely attempted legislative gambit may force a vote on DACA legislation. Laura, D.C. is buzzing about the discharge petition. What is it?
Yeah, well, there's a lot of kind of little known and wonky parliamentary maneuverings going on here. So let's start from the beginning and kind of unpack things a little bit. In March, Rep. Jeff Denham, a Republican from California, introduced what's called the Queen of the Hill resolution, which would bring 4 different immigration proposals to the floor for a debate. The Securing America's Future Act, which is Rep. Bob Goodlatte's kind of more conservative legislation. The DREAM Act, legislation that provides a path to legalization for dreamers. The USA Act, which is compromise bipartisan legislation introduced by Reps. Hurd and Aguiar, couples border security with kind of a DACA fix, and a hypothetical bill that would be of House leadership's choosing. If this Queen of the Hill resolution was to go forward, all 4 legislative proposals would be subject to a debate. Moving forward, whoever wins, gets the most votes over 218, becomes the Queen of the Hill and is then sent to the Senate. So it's important to keep in mind this Queen of the Hill resolution that they're talking about isn't actually legislative policy. It is what would trigger a debate over 4 various options. It hasn't advanced through the traditional channels, so to force things forward, supporters of immigration reform and this Queen of the Hill resolution introduced what's called a discharge petition, which is kind of another parliamentary maneuver that would bring things out of kind of the traditional legislative order and discharge this resolution straight to the House floor.
So normally how it would work is the Speaker and House leadership would decide what bills get considered on the floor. They would decide what bills get considered. This discharge petition bypasses that process. Skips over the committee process, skips over the leadership selection process, and brings things straight to the floor. So as you can probably imagine, it isn't popular with House leadership. They like to be the ones that kind of control what goes on and off the floor. It's also very rare. It doesn't happen. Discharge petitions get introduced a lot. They rarely make it over the threshold. I think the last time it happened was maybe 2003 with an export-import bank measure. But that one's kind of unique because it had the tacit blessing of John Boehner. And Speaker was moving it forward, even though he wasn't technically part of the process. So this one's really unique, that it would be a true kind of uprising by the people. And it's unique in that it's not just, we want to consider this one piece of legislation. It's
just
we
the
want to consider
Queen of the
4
Hill structure is unique in and of itself. They set up a debate on 4 different possibilities, and then the way this resolution would even come to the floor through the discharge petition is unique too.
So if something did get a majority, at least one of these 4 possibilities, what do we think would be likely to happen in the Senate?
Not much. The Senate kind of had their debate earlier this year. I think they thought the way they structured it, by allowing several different amendments to come forward, I think Leader McConnell feels like he gave this issue its fair shot. They would have the option of taking it up again. I'm not sure they would have the will to take it up again.
So as we're sitting here today, this petition is pretty close to getting across the finish line. If you assume all Democrats sign on.
It's pretty close, yeah.
We're about 5 votes short, right?
Right.
So but there are some pretty specific rules that have to be followed when it comes to gathering the signatures. How is that going to work to get these last few signatures?
Yeah, so for those who haven't worked on Capitol Hill or have familiar with kind of how things work mechanically, to sign on to a piece of legislation, you fill out a piece of paper, your boss signs it, you bring it down and drop it in the cloakroom, whether the Democratic or Republican cloakroom. This one's a little bit different. You have to actually physically approach the well of the House of Representatives in person and sign your name to the discharge petition face-to-face. So it kind of does lend an interesting dynamic that anyone can see when you're heading towards the well to sign your name. If they don't want you to sign your name, they can come chat with you about why it's in your best interest to stay off, distract you, pull you to the corner to grab a cup of coffee, whatever they want to do.
Real life arm twisting.
Real life arm twisting. And you can kind of watch it all unfold because the floor is a public space. So it does add a little bit of a palace intrigue or kind of a different dynamic than traditional co-sponsorship where you just kind of get on behind the scenes.
So the big question then, do we think this petition will make it to 218 votes? What are you hearing at this point?
I think it remains to be seen. I don't know if this petition makes it to 218, but I think the House has a debate on immigration. My guess is kind of reading the tea leaves. Leadership, as we've discussed, leadership doesn't really like things to come to the floor in this manner. They like to be able to control the process. I wouldn't be surprised as we see the number tick up closer to where this resolution might be discharged. Leadership doesn't swoop in and kind of come to some kind of agreement with the folks pushing this discharge petition. I think leadership wants to control the process a little bit more. I would be surprised if the discharge got to 18 and things kind of proceeded without the blessing of leadership.
Okay. Thanks, Laura.
Thank you.
Theresa, it's been reported recently that Attorney General Jeff Sessions will refer some immigration court decisions to himself for review. Can you explain what that means?
Right. So I think we've talked a little bit before about how the immigration court system works in this case. The immigration courts are actually an office within the Department of Justice. So technically, all of the immigration judges are employees of the Department of Justice, and the immigration court system itself, it reports directly to the Attorney General. He has oversight over all of the immigration courts. One of the authorities that gives him is the ability to take immigration court decisions and decisions from the Board of Immigration Appeals, which is the appellate body for immigration courts, and take them to himself to look at those decisions and decide whether or not he himself might want to overturn an underlying decision. And so this is an authority that's always existed, but it's been used relatively infrequently. It's only been used a couple of times under the last two administrations, although George W. Bush administration did a few more of them. But what's significant here is that a lot of court watchers and immigration watchers look at the cases that he's selecting and thinking that he's trying to set some precedents here, and that could have some impacts over time.
It sounds like there are specific kinds of cases that he's referring to himself. What are those?
Right. So two different kinds of cases. The first couple have to do with the authority of the immigration judges to regulate their docket. An immigration court docket is the schedule of cases that an immigration judge is set to hear. And judges have generally a lot of leeway to schedule things the way they want. They can prioritize certain cases. They can offer a person in immigration court a chance to extend the time that they have to prepare their case. That's called a continuance. An immigration judge, if he thinks that the case is going to be settled somewhere else, for example, the applicant has an application for a benefit pending at Citizenship and Immigration Services that would render the current case moot, could close the case administratively on their own will. So two of the cases that the Attorney General has referred to himself have to do with these kind of administrative things. One is the ability of immigration judges to issue continuances. And we know that from other things that the Department of Justice has done, they're looking for ways to speed up the court process, and these continuances do drag things out. There's a record court case backlog in immigration courts.
Yeah.
So by reducing the ability of immigration judges to issue continuances, he would basically mandate that everybody has to be prepared and the cases are going to move faster. So that's one of the things he's looking at. Another one is the ability of an immigration judge to close a case when then there's something else pending. In this particular case, the Attorney General is trying to figure out whether or not, while there was still an outstanding question of law in the case, the judge was right to close it because the applicant basically had another avenue of relief available. The second type of case, and this is probably more relevant to a broader set of cases, is a case that he's looking at about whether or not someone who is asking for asylum based on being a victim of crime or of gang activity can be considered a member of a particular social group and therefore eligible for asylum. We talked about this a little bit before. The asylum law is very strict about what constitutes persecution. You have to be persecuted on account of your membership in a particular social group, your race, your religion, your political opinion, something like that. But that social group membership has been expanded by various other court cases to say, well, maybe if you are subject to domestic violence and your government has been unable to protect you, you are a member of a social group of domestic violence victims from country X. Or if there's generalized gang activity that's been aimed at people in certain situations like you, like your brother was a gang member who renounced, so you are subject to persecution and your government can't protect you. Depending on how the Attorney General decides in these cases, he may overturn those precedents and say, nope, that's a too expansive definition of a social group. And that kind of decision would have a direct impact on a lot of the people who've been applying from Central America in the last few years.
What happens if he does overturn decisions of immigration court judges?
So if it's in an individual case, obviously, whatever decision he overturns affects that individual immigrant, the particular case.
Sure.
But when he does make that and designates that case as a precedent, then that means that his legal reasoning has to apply to every immigration judge and every other adjudicator looking at a similar set of facts.
Wow.
So it could have impact to a lot of cases that are based on similar circumstances.
So what do you see as being the broad impact then for future immigrants coming through the immigration court system? This could be huge.
This could be huge. I mean, immigration courts, like other judicial courts, rely on precedents. Judges look at an individual case, they look at the facts of the case, they compare it to the law, and when there's some question, they look at, well, what have other judges ruled? What have the appellate judges ruled? And what's binding on me then to decide? In the immigration court system, although it's not a judicial court, it has some of those similar things. So you have immigration judges, then you have a board of immigration appeals, then you have the attorney general, and then there are also federal courts that have weighed in on some of these cases as well that all apply. So when the attorney general comes in and overturns something, it resets all of that legal house of cards, if you will, and says, oh, this piece down here, we're now changing that, so we need to rebuild that based on this new foundation. That can affect all future cases. It doesn't usually have a retroactive impact, but it affects all current, pending, and future cases that are like that.
Thanks, Theresa.
Mm-hmm.
Finally today, Sessions and DHS Secretary Kirstjen Nielsen announced they will refer 100% of people caught entering the U.S. illegally for criminal prosecution. This might also mean that some parents are separated from their children if they're traveling together. Chris Ramon, first, how is this a change from previous policy?
So there's two ways to look at how this is both a continuance of previous policies and a shift. In terms of continuing policy, you and I have spoken a couple of times on this podcast and another one as well about how Bush administration and the Obama administration had increased the number of prosecutions of individuals entering the country illegally and re-entering the country illegally, and how that, basically increased the jail population. So with this announcement that there's going to be a zero tolerance and that there's going to be an uptick in the number of prosecutions of illegal entries, that's a continuance of what we discuss as Operation Streamline. But there's also the potential with the prosecutions of seeing these parents also being prosecuted under what is INA Section 1324, which is smuggling individuals. And so this is another area of the law where there are criminal penalties where you can be pushed. Instead of going through the administrative court systems for immigration removals, you're getting pushed into the criminal court system because you're violating the INA. You're being prosecuted for these criminal violations. So in that sense, like you said, it's both a continuance of things that we've seen before, an increase in prosecutions.
Yeah.
But a divergence because you're now adding in another component of law that hadn't really been prosecuted that now is being put into effect.
So what's the rationale for this change, and how do we see this actually working at the border? How will this be implemented?
The rationale, much like the increase in prosecutions of legal entries and reentries, is deterrence. Basically, we're going to make it really difficult for you when you get here, and we're going to make it so difficult. We're going to put you through the ringer, through the criminal court system, and through the criminal justice system that, guess what? The cost of coming here is going to significantly outweigh the benefits. So that's the whole purpose. But, how would it actually work at the border? There's a couple of ways that this can work. One, previously, if you were a family and you were a family coming through, you'd be taken into custody. You'd be considered. There would be potential discussions about whether or not you can claim asylum. And then the families would be put together and subsequently processed through the administrative court systems for removals. What would happen now, what you would be seeing is, with the separation, is that the parents would be separated from the children, and the parents would then be put through criminal justice proceedings, you'd be prosecuted by the DOJ, you'd be appearing before a district judge, so in the federal court system, a decision would be handed, and then you'd be put into, if found guilty, you'd be put into federal prison.
Do courts and federal prisons have the capacity to adapt to this change? How will this impact them? It seems like it could be substantial.
Basically, I think, with all honesty, I mean, that since Operation Streamline came into effect, it's kind of just part of the system now. I mean, really, like, prosecuting individuals for entering the country illegally is really pretty much what has been done. I mean, you're looking at the stats, prosecutions for illegal entries and reentries, although they've dropped off, there's still significant numbers of prosecutions for federal violations. And so in that sense, that's not going to necessarily impact that. And, what you might actually end up seeing is might be seeing more individuals entering federal prison. And that's more of a question of capacity of whether federal prisons can do that. But already non-citizens, many who have been prosecuted for illegal entries and reentries, are already a substantial population. So you're just going to see that population potentially increase.
Theresa, what happens to the children and why would they be separated?
So one of the primary reasons they'd be separated is because if someone is being prosecuted criminally for an immigration violation and they go into the criminal justice system, they're then housed in a criminal jail. Immigration detention is not a jail per se. It's considered a separate thing, although the lines get blurred because some local jails basically hire themselves out as immigrant detention centers, but the conditions are different. And so once you're put in the criminal system, you'll be housed in an adult criminal jail until your hearing is done. Children can't be put in that situation. By law, they're not allowed to. And there are specific laws about how children in immigrant detention can be treated. If they are separated from their parents, they'd be then considered an unaccompanied child. They would be subject to transfer to Health and Human Services Office of Refugee Resettlement. They're a government agency that oversees care of unaccompanied children. They might be placed into a child center that is overseen by ORR. They could be placed into foster care, but ORR eventually tries to reunite them with family or other relatives in the United States. And that's what usually happens to them. So if they arrive with a parent and they're separated under this process, it could be many, many months before a parent and a child could be reunited at any time, whether in the United States or outside the United States. Parents who are criminally prosecuted, if they are then sent to jail, would serve out their criminal jail time and then be put into removal proceedings. And they may continue to be detained in the immigration system at that point until the removal proceedings are happening. So again, that could be a long-term separation.
Cris, as you said, we've tried some of this stepped-up prosecution efforts before in the past, and there's been quite an effort to do that. What have we seen so far, and what inferences can we draw from experiences so far as to whether this actually will deter people from trying to enter the United States illegally?
Right. So there's two things to consider. I mean, when we were talking about Operation Streamline and the increase in prosecutions for illegal entries and reentries, government reports, the jury was out. They were saying there weren't enough metrics. You saw some drops in number of apprehensions of people coming through, but there weren't enough metrics to fully verify whether or not that was the case. But with this specific instance is that DHS, when announcing this policy, they were saying that the El Paso sector of the U.S.-Mexico border, that there was a drop in 64% in number of family unit apprehensions. Family unit meaning parent and children who were apprehended, there was a drop. But, Dara Lind over at Vox, at least, she had an exchange with DHS, and this was discussed in an article that she published on the website, where eventually what DHS revealed is that there was a 64% drop in that sector in overall apprehensions. And that's, if we're going to take that as at face value, it's kind of like, well, is this a drop in number of individuals coming in here or family units? And if this policy really is being targeted at families coming through in order to sort of deter individuals fleeing their countries, and in order to deter these, because this is really where the uptick in the recent surge of number of apprehensions have come in from families. If that's really the case, then the jury is once again still out whether or not the adoption of this policy is actually going to be serving the purpose, which is to deter the entry of families fleeing largely Central American countries.
So, Theresa, putting aside the question of whether it will deter people from entering the U.S., is this the way we want to deter people?
Well, that's the big debate. And certainly a lot of immigration advocates are outraged. I think we've heard a lot of pushback even here in Washington. Traditionally, the reason we haven't done this is because it's considered very cruel. We are separating families for the sole purpose of telling them don't do this. It's a harsh way to deter. It's certainly, we know that it has negative effects on children who are separated from their parents. And again, going back to what Cris said, a lot of the reason these people are coming is because they frankly fear death if they stay where they are. So they're already facing potential separation. If you remember in 2014, before we saw the large numbers of families coming, we saw a lot of unaccompanied kids. People were already willing to send their children alone on a dangerous journey of hundreds of miles to try to get to the United States. It seems to me that if they're already ready to do that, this kind of separation may not be the deterrent that the government thinks it is. And in the meantime, we're separating a lot of parents and their kids. And is that really what we want to do?
Thanks to you both. That's our show for this week. Thanks for listening, and a special thanks to our producer, Emily Schroeder. Please take a second to find us on Facebook by searching Bipartisan Policy Center, or on Twitter at BPC_bipartisan. And don't forget to subscribe to this podcast, as well as all of BPC's podcasts on Apple Podcasts, Google Play, or wherever you get your podcasts. Just search Bipartisan Policy Center. Join us again next time.